Why the Supreme Court should overturn the Presidential Election Petition Court PEPC verdict. Welcome to the news and thank you for tuning in to listen. Please subscribe to our channel. To get notified when we post hot juicy news updates, please click on the notification bell. We all foresaw the vexatious verdict of the Presidential Election Petition Court PEPC delivered on 6 September 2023, 6/9 verdict, censored that the PEPC would thwart substantial justice. The people began by erecting billboards, signboards, and posters in Abuja with the inscription, "All eyes on the judiciary." To stop that inscription was pricking their consciences and passing judgment on them. They went about pulling down the billboards and yanking off the posters. However, the more they did that, the more billboards and posters sprang up in town and on social media with the aid inscription. A few media with the said inscription. A few days before the unveiling of a 6/9 verdict, they engaged in blackmailing the citizens and warning them not to let the heavens fall simply because the outcome of a judgment was not in their favor. An undertaker publicly showered encomium on two lawyers representing President Bola Tinubu and the PEPC, Wale Olanipekun San and Lateef Fagbemi San, describing the duo as experts in election petition matters. The authorities announced beefing up tight security in Abuja to avert possible violent protests against the looming injurious verdict. The PEPC, which had earlier rejected people's application to televise the proceedings of the PEPC, suddenly announced that it would televise the delivery of the verdict, ostensibly to give a false impression that it subscribed to integrity and transparency. Seeing the iniquities of 6/9 verdict was delivered, the country has been steeped in deep mourning. The unjust verdict continues to draw the eye of the people, especially the Nigerian youth. There are times that try men's souls in Nigeria. We live in the most perilous times. Anyone who has not yet come to terms with this truth may be living in a fool's paradise. Although the bullets may not be crisscrossing the airspace, the pre-existing legal order may not have been violently uprooted, and the heavenly firmament may not have evaporated. But the 6/9 verdict has smothered the remnants of the empty carcass called Nigeria. Augustine means no words about it. When justice is taken away, all that is left in the kingdom are great robbers. Say whatever you like, but no man or woman of good conscience in Nigeria can be at ease with the vulcanized 6/9 verdict. Equally, no street, no Broadway, no village path in Nigeria can remain silent amid the stillness of a death occasioned by the 6/9 judgment. Peace is not the absence of external war. With torn and bleeding hearts, we may be smiling, but we may not know peace until Nigeria goes the way she has been fated to go. I repeat, Nigeria must go the way she had been fated before the dawn of human flourishing in Nigeria. Perhaps what is more perplexing about the riveting 6/9 verdict is that the five-member, the PEPC, with the greatest respect, wrongly descended into the arena of conflict. Inherent in our adversarial court system is the principle that a court must not descend into the area of conflict in favor of any of the parties in a case before the court. See, among other cases, Ayode vs. Springbank PLC 2014, Nwafor vs. Nigeria Customs Service, and ORS 2018, where the court held that a judge should not descend into the arena of conflict to make a case for a party. Why? Because it is against the run of a game and tenet of adjudication. Unfortunately, the PEPC, with greatest respect, grievously erred in this aspect of our law. The PEPC constituted itself as the counsel to the respondent and was arguing the respondent case in descending into the arena in favor of the respondent. The PEPC treated with levity the overwhelming evidence tendered by the petitioners, establishing that President Tinubu was illegally and unconstitutionally pronounced the winner of the February 25th presidential election by Professor Mahmood Yakubu, chair of the electoral body INEC, amidst complaints that the election was rigged by INEC. Like a hired assassin, the PEPC proceeded to decapitate the petitioner's petition, including the cloud of petitioner's witnesses. The PEPC struck out all the vital paragraphs of the petitioner's petition on flimsy and illogical grounds. It rejected all the laws and legal authorities cited by the petitioners on pseudo-rationalization. One cannot help but feel a moral whiplash. You will recall that during the hearing, the respondent counsel did not impugn or discredit the overwhelming evidence adduced by the petitioners. They promised to do so in their final address. Unfortunately, the respondent failed to do so during the final address, yet the tribunal entered final judgment in their favor. It is right and it is right and in consonance with the principle of a natural justice that a court of law must remain unbiased umpire in a case before it. The court cannot manufacture legal argument or evidence for any of the parties. The court must rely on the defense of the party as it is put forward by the party. The court must not manufacture a defense for a defendant. For a defendant in a suit to succeed, he or she must succeed on the strength of his own defense, not on the strength of the defense manufactured for him or her by the court. It is sad that Nigerian judges handling high-profile election cases are now accountable to the politicians in law court cases rather than to the rule of law. This is why the jurisprudence of these judges is so disconnected from the Constitution and the Electoral Act that it sometimes seems to defy explanation. In terms of the overall performance and the meeting justice and needs of people, our judges should remember that they are accountable to the rule of law and the Nigerian people, not to the P2Bs, Bola Tinubu's or Abubakar Atikus of the world. Mind you, the P2Bs, Bola Tinubu and Abubakar Atiku will come and go, but the rule of law remains unaltered. Serving the succeeding generations of mankind. Consequently, our judges, with the greatest respect, are advised to interpret the law in a way that meets substantial justice of a particular case or in a way that fulfills the needs and aspirations of the Nigerian people, as envisioned in Section 13, 14, 1, 2, ABC of 1999 Constitution. Dismissing an important electoral petition concerning the character of President Bola Tinubu to hold an exalted public office on mere whimsical and capricious technicalities. In my humble view, is a disservice to what is reasonably justifiable in a democratic society. The paradox of it all is that during the inauguration of the PEPC in Abuja, the most excellent Justice Haruna Samani asked lawyers representing all petitioners to avoid unnecessary technicalities and address the substance of their cases. Yet, the same PEPC used technicalities in dismissing the cases of the petitioners.